Good morning. Today we will see a judgment on International Commercial Arbitration. GA number 1 of 2021. KAC Electricals Private Limited versus Project Director Bangladesh Rural Electrification Board. This judgment is by Calcutta High Court. KAC entered into a contract with Bangladesh Rural Electrification Board. Hereafter we will say BREB for supply of some material. KAC submitted a performance guarantee in terms of the contract issued by Eastern Bank, which is a Bangladesh bank, covering 10% of the contract value. Yes Bank, which is an Indian bank, issued a counter guarantee to Eastern Bank for KAC to secure Eastern Bank Dhaka, that is Bangladesh. KAC filed an application under Section 9 of Arbitration Act, interior measure for protection by court, on receipt of a letter from BREB calling upon KAC to deposit $10,000, failing which a threat was issued to invoke the performance guarantee to the tune of nearly $10,000. The case of KAC was that BREB wrongly withheld 10% of the contract value as retention amount and refused to release the performance guarantee. A notice was also issued by Eastern Bank informing KAC based on a request made by BREB to Eastern Bank to encash the bank guarantee. We have already seen 10% of bank guarantee was given by Eastern Bank and a counter guarantee was given by the Yes Bank, Indian Bank. Now, the issue before the Calcutta High Court was whether Calcutta High Court has got jurisdiction to entertain the matter because it is an international commercial arbitration. Second, if yes, whether KAC has established a case for sustaining the injunction order on Yes Bank not to release the 10% of the performance guarantee to Eastern Bank. These are the two questions because Yes Bank has given irrevocable bank guarantee. On jurisdiction, the Calcutta High Court, on going through the general conditions of contract, noted that the clauses provide that the contract shall be governed by the laws of the purchaser's country, that is BREB, Bangladesh. However, the court held that it would not stand in the way of the High Court, assuming jurisdiction of the matter, since the governing law of the contract, that only will decide the substantive provisions of law, which would govern the arbitration between parties. In the case of international commercial arbitration, court under Arbitration Act means the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions if the same had been the subject matter of the suit. This is very important. If the same had been the subject matter of the suit. The pleading indicated that sufficient cause of action has arisen within the jurisdiction of the Calcutta High Court. Further, Section 2.2 of Arbitration Act provides that subject to an agreement to the contrary. Again, this is very important. Subject to an agreement to the contrary, the provisions of Section 9 shall also apply to international commercial arbitration despite the place of arbitration being outside India and an arbitral award made or to be made in such place is enforceable under Part 2. It is for execution. The present contract does not exclude the applicability of Part 1 of Section 9 of Arbitration Act. This is what the Calcutta High Court says. The Calcutta High Court held that wide and unfettered powers of a court under Section 9 has been reiterated under countless decisions, which closes the loop for a party to object to the interior measures under Section 9 unless the parties have specifically and unequivocally agreed to exclude the operation of Part 1 of Arbitration Act. Further, the court held that since the arbitration agreement does not indicate a place or a seat, the court has full jurisdiction. Calcutta High Court held that even in cases of commercial arbitration, High Court has jurisdiction to entertain the matter. There are 2 points. This is with regard to the jurisdiction. First point is over. Second point is whether the irrevocable bank guarantee has been issued by the Yes Bank. We have seen whether stay can be given against that irrevocable bank guarantee was the second issue before the Calcutta High Court. With regard to the second issue, the High Court noted that KSE had supplied the entire material under the contract. It received 90% of payment. 10% of contract value is retained by BREB. KSE made payment for alleged shortfall of the materials. Whatever it is, there are some small minor mistakes, they have made the payment for that. There is no further sum which BREB is entitled to realize from KSE. BREB had not made any claim for damages and is fully secured by retaining 10% of contract value. Already they have 10% of the contract value. The High Court noted that the order of injunction was communicated to Eastern Bank well in advance. This is very, very important. Order of injunction was communicated to Eastern Bank well in advance. In spite of the injunction, Eastern Bank paid to BREB. Having subverted the orders passed by the court, Eastern Bank must bear the fallout of its action and cannot now use the same as a pretext for fighting a proxy war across the border through Yes Bank. The cases relied on by Yes Bank that unconditional bank guarantee results in an absolute obligation was negated by the High Court on the ground invoking the exception to the rule, namely fraud would vitiate the very foundation of a bank guarantee. The application filed by Yes Bank to vacate the interim order was dismissed. Thank you very much. Have a great day.